we begin the show with a conversation with the Special Investigating Unit head. And you will know that the SIU has been investigating several cases of alleged corruption in the procurement of personal protective equipment during the coronavirus pandemic. Now, one of the key areas of focus was the irregular awarding of the Digital Vibes contract by the Department of Health. Now, the unit has been investigating several cases across all 9 provinces. Joining me in studio now to talk progress as far as these investigations are concerned is Advocate Andy Mothibi, the head of the Special Investigating Unit. Mr. Mothibi, thank you very much for making time to come talk to us here in studio, in person. We know you're a very busy person. I'm not going to waste time. I want us to go straight into the Digital Vibes matter. And I want to kick off with part of what your presentation touched on. Take us back to July 2019. This was the time where you say several attempts were being made to employ Ms. Tahira Mather as the contractor for communications in as far as NHI within the Department of Health is concerned. Who was the official behind these efforts to see to it that Tahira Mather was employed there, together with the company that she represented, of course, Digital Vibes, as the contractor for the department?
Right. Thank you so much for inviting us to come and engage with you and, of course, the public on this topic of the fight against corruption. We really appreciate this opportunity. Indeed, yesterday we presented our progress report to SCOPA, and it was based on the progress report that we submitted to the President on the 30th of June 2021. And the content and the data in that report is as at the end of May of 2021.
Yes.
But that matter that you talk about is a matter that would have been included in the 6th progress report, which is due to be presented to the President in this week. So we included it in the presentation to SCOPA, simply that SCOPA called on us to present, and of course we informed the Presidency that the content of our presentation to SCOPA is going to include the Digital Vibe, which would ordinarily have been in the 6th progress report, right? So that's really the sort of governance framework. But now, with regard to that question that you raise, we received the report that, of course, with the allegations that there were irregularities around the award of the Digital Vibes contract, right? And then we set off to investigate. So part of the investigation findings is exactly that, the point that you're making, that the evidence that we have gathered points to the fact that there was this initiative to appoint Ms. Mather as the consultant in the department, but that part I think didn't really go through, and that's when now the initiative started to now go out and seek to appoint a service provider, which ultimately happened to be Digital Vibes company, to which the same Ms. Mather is a part of. And initially, as you correctly say, we have found the evidence that indicates that that company was initially contracted for purposes of NHI services, communication services, and when the disaster was declared, relating to the COVID-19, again, based on the evidence we have gathered, is that there was this process that was initiated, again, seeking to appoint Digital Vibes now as the COVID-19 communication service provider. And there were processes you would have seen in our presentation, approaching the National Treasury for deviation, and the National Treasury really did not support that.
Yes. And
there was now this process to go out in the market to just select about 10 or so companies, but Digital Vibes happened to be also included there. And in the process of the adjudication, and I use adjudication generally because there would have been probably the bid evaluation company and committee and some of the processes. But if you see, the evidence that we have picked up really indicates that there was a measure of manipulation of that process, because we found that a company that was suited in terms of our evidence that we uncovered actually came up second, because Digital Vibes was scored in such a manner that it emerged as the winner. So
I'm going to interrupt you there,
right,
Advocate Mothibi, because I will bring up this company in a moment that was competing against Digital Vibes.
Right.
Who was pushing for Digital Vibes to be appointed the communicators when it came to NHI? Because this seemed to have been a concerted effort. National Treasury was not approached once. It was on several occasions, as per your presentation.
Yeah. Look, on that score, the evidence that we have really picked up, particularly from the part where the budgets were looked at, right? The evidence we have picked up is that there was budget that was approved, right? And when the budget was approved, the name of the company Digital Vibe was there on the approval of the budget. And ordinarily, it shouldn't be like that. Mm-hmm. Ordinarily, when a budget process starts, you approve a budget for a particular initiative that the company or the department would embark on. The issue around the service providers comes way after, because that's a procurement process.
Yes.
So the budget gets approved for purposes of supporting the objectives of the company and the targets of what they need to do.
Yes.
If it's a communication initiative, well and good, it would have been computed and budget signed. But in this case, the evidence that we have uncovered is that when budget was signed off, the name Digital Vibe was there. That now to your question.
Yes.
To your question, colleague, in terms of who would have pushed, that's something that will probably be ventilated also in the court process, because you know that this matter now is at the special tribunal, and we're talking like this simply because it's contained in our papers that are public at the special tribunal. So the question of how did the Digital Vibe get to be mentioned when the budget was approved?
Yes.
That part is a part really that was a problem, and we need to really ensure that when the matter is ventilated in court, that also gets attention.
I will respect the element about some of the detail needing to be exposed, if you like, at court process level. But I will ask this question. Is it true that in your court papers there may be evidence suggesting that the introduction of Ms. Matha and Ms. Mitha, who is said to have been a personal assistant, they were introduced very early on, in fact, during the what do you call it, when ministers are appointed, there is that process where they are sworn in. I think it was the swearing-in ceremony. Is it true that, contained in your court papers, these two individuals would have been introduced to the department's Director General at the time?
Right. Cody, as I indicated, I obviously have to be cautious because this matter is now at court. There is evidence to that effect. I think suffice to say, it's an accurate observation. It does look like you've read our papers. There is accuracy in that observation, and in fact, part of what we found as evidence is that when this name was introduced even in the COVID-19 initiative, communication initiative, there is one official in the department who actually raised the flag, right? And said, you know, from his research or checking, because as a SCM or supply chain manager or supply chain management official, you're required to do some certain sort of due diligence. It looks like that official did that, and a flag was raised. And that flag, in terms of the evidence, we couldn't find that it was really given attention. And the flag was raising the background to these names. That these names seem to come from Kokta, and now they find themselves in the department and so on. I think it would suffice to really paint that picture. The details will be presented at court.
All right.
But I think that sufficiently responds for now to your question in terms of, you know, some of the, you know, origins of how this company could have come in.
Yes.
And by the way, there's also evidence that we have picked up when this matter was looked at, that another official in the department, right, would have gone out when this matter was put down as a consideration to do the COVID-19 in communication, that these names would have been solicited from another department. So I'm obviously cautious because this matter will be ventilated fully in court. Yes. But I think I'm just giving an indication that we do have evidence. We do have evidence that indicates that there might have been a concerted effort to really ensure that this company ultimately comes out as a winner.
All right. When we return, we are going to talk to Advocate Andy Mothibi about the alleged role of the then Minister of Health, Dr. Zweli Mkhize, and importantly, the competence levels of Digital Vibes for them to have won this contract. The conversation continues now. We are in conversation with the head of the Special Investigating Unit, Advocate Andy Mothibi. And Mr. Mothibi, before the break, I alluded to the role of the then Minister, or should we say the recent Minister of Health, Dr. Zweli Mkhize, in the appointment of Digital Vibes in the Department of Health. The bending, because that is what clearly you have presented to Parliament in your progress report, on the appointment of Digital Vibes as a communications consultant for the department. The bending of procurement processes are all there for all to see. That can only mean that Ms. Mather and the company she represented, Digital Vibes, would have had a powerful individual that was pushing for these rules to be bended in order for them to be appointed, whether by hook or by crook. I'm going to ask you very directly. Was the former health minister, Dr. Zweli Mkhize, that person?
Cody, I would immediately say that there is no direct evidence that says the minister is that person, right? But as I said, there is evidence that there would have been some interaction, and I mean it's out there in our court papers that there would have been some communication from the minister to the then DG through WhatsApp communication that would have said, you know, I think if you read the papers, it says sort out the contract, right? And I'm mentioning this because it's out there in public. So then this again will be ventilated at court in terms of just going to the bottom of the substance of that communication.
Yes.
And by saying sort out the contract, which contract was it referring to? What reference in the circumstances of what we have picked up was that message referring to?
Yes.
And remember, at that time, there was already a budget signed off, right, by the minister, where the name Digital Vibe was there. It's out there in our papers, and
yes.
It looks like you have read them. And again, we will present at court to say what are the rules and regulations relating to, you know, budget approvals, approving budget to support a certain policy initiative, because at an executive level, there's a connectivity towards ensuring that policy initiatives of government are implemented, but there's also a very important line not to cross when it comes to administration matters, especially where they include service providers and procurement matters.
Advocate Mothibi, during the process of conducting your investigations, I assume that you interview the parties that you suspect to have been involved in wrongdoing. Did you interview the former minister, Zweli Mkhize, and what did he say was his relationship with the people who run the company Digital Vibes, and vice versa? Did you talk to those who run Digital Vibes, and did they say whether there was a relationship between themselves and the minister?
Yeah. Look, our investigation process, of course, and as we always say, our investigations are allegations-based and the findings are evidence-based. So to make the findings that we have made in our investigation, we of course base them on the evidence that we gathered. And during the investigation, having made certain findings that would have made us return adverse findings against the former minister, it was incumbent to ensure that we also give him the opportunity to be heard. In fact, our legal provision says we call the witnesses under oath to be questioned relating to some of the findings that we have made. We did give the former minister that opportunity, and I really want to say the minister cooperated from the onset when the investigation started until the time when he was required to come and then be heard under oath. The unfortunate part for purposes of this discussion is that I'm not at liberty to disclose the contents of his testimony.
But he did testify under oath.
He did come and be questioned under oath. Yes, he did. And part of that resulted into us making sure that these findings that we have made have taken into account what the minister has said to us.
Advocate Mothibi, let's talk about Digital Vibes and the experience they possessed for such large amounts of money to have been paid out to them thus far. Contrast their experience versus the second bidder, which you spoke about, which you say lost out.
Right. As we looked at the procurement process, our investigators really went into detail in assessing the process and looking at the companies that were looked at, and of course the competencies. Right? So our evidence indicates that at the time of the procurement process, the assessment indicates that Digital Vibe had only, I think, 1 year experience, whereas the other company, now I won't be exact now, and I don't want to mislead you and the public, but it had really several years of experience. So, and we looked at some of the competencies of the members of those companies, and it's really our view. It's really our view that the Digital Vibe was really not fitted in the circumstances, and that the process was irregular. And that is why we are at court now, amongst others, or the special tribunal, that is, to declare that contract unlawful, irregular, and set it aside so that we can also recover the monies that have been paid. And you might have seen in our presentation yesterday, and it's even in the court papers, that the money, once it was paid, there's a myriad of companies that were paid out, and we are in the process of ensuring that those monies are further tracked and are recovered. As of I think Monday this week, or Monday or Tuesday, there's a further company that came out and said, I need to pay back the money. In fact, they paid back into SIU trust account 11 million this week. And that is after...
Why did they volunteer to do this?
I wanted to come to that. It's simply because they were confronted by our investigators, and we wanted to ascertain the kind of role that they played. And we determined that they actually did not perform any service to the department. And they acknowledged and they agreed to pay back that money. So it is so important for the public to know that the investigations really went to the extent of even seeking to identify each and every company that benefited here, and seek to understand what was it that they thought was their role when they got the payment.
You talk to the thorough process that you go through, Advocate Mothibi, and your team when you conduct these investigations.
Yes.
I'm going to go back to the Minister now. In your presentation to Parliament yesterday, you conclude with these words that the former Minister, I quote now, may have committed actions of criminality, close quote. Are your findings conclusive, Advocate Mothibi? Because if they are conclusive, then when you say may, that puts doubt.
Right. No, thanks for that question. And you would see that part appears in our presentation, where we talk about the accountability of the executive authority, or holding the executive authority to account. Because let me put context to it, is that in every investigation that we do, right, we clearly seek to identify the accountability from the junior official to the executive in the company or in the department, and to the executive authority. So we determine accountability at all levels.
Yes.
And accountability could be either from a civil liability or criminal liability, or disciplinary action needing to be taken.
Yes.
Right? So when we investigate maladministration, malpractices, corruption, and other related other offenses that we get to pick up,
yes.
Like fraud, theft. So when we pick up evidence pointing to an offense being committed, by law, by our legislation that enables our investigations, we are enjoined legally to refer that evidence to the NPA. We also refer to the Directorate for Priority Crimes Investigation, known as the Hawks, so that that matter could then be looked at further, because it is only the NPA, through their ability and their responsibility to decide on whether that evidence is conclusive to return the charge. So when we investigate, we do know, our investigators are trained in terms of the criminal law elements. If the crime is corruption, remember there's a Prevention and Combating of Corrupt Activities Act that sets out all the elements of what corruption is. And our investigators are trained around that. And when we see the evidence pointing to all of those, we are satisfied that this evidence needs to be referred for consideration by the NPA so that they can decide whether to return a charge of corruption or any criminal offense. Hence the usage of the word maybe.
Okay. Right. Talking about the National Prosecuting Authority, when we continued this conversation, the SIU telling Parliament yesterday that they have referred 19 people, or perhaps in that 19 it could also be companies. We don't know. He's going to clarify for us who perhaps might be among these 19. We continue in a moment. If you're just joining us, you find us in the middle of a conversation with the Special Investigating Unit Head, Advocate Andy Mothibi. And before we went on that break, Advocate Mothibi, we were talking about matters that you have now referred to the National Prosecuting Authority for prosecution.
Yeah.
19 people. Is it 19 people? And are companies involved in these 19? And perhaps I'll be even more specific in order to break the suspense out there. Is the former Minister of Health possibly among those people that have been referred to the NPA for criminal prosecution?
Right. As I indicated before you went on break, that if we pick up evidence pointing to criminal action, we are enjoined legally to refer to the National Prosecuting Authority. So in this PPE investigations so far, we've actually referred more than 100. You're actually just focusing on the ones we referred in the Digital Vibe investigation. But in the overall investigation, we've actually referred more than 100 criminal evidence to the NPA for consideration. And, of course, the Hawks is also involved. Even in this one of the Digital Vibe, the Hawks is involved, and we're working together interagency to ensure that that evidence is further considered. So there's several individuals from officials in the department and companies that the evidence points to.
Okay.
Right. So at this stage, again, before the evidence is fully considered and a decision is made either way to charge or not to charge, and whoever is charged appears in court, there is generally a legal risk to mention the names.
Okay.
So at this stage, Mr. Mgambi, I would really say, suffice to say, we have referred evidence that points to criminality, and that's why we said that evidence also points that the minister may have also, contravened the Prevention and Combating of Corrupt Activities Act, and we have referred that for consideration. So at this stage, we would like that process to unfold so that it's considered effectively, and then a final decision will be made.
Now, the former minister is not the only person possibly implicated here. The Director General of the Department of Health, the current Director General, Dr. Sandile Buthelezi, the understanding is that he may be among the officials that are in your sight as far as possible wrongdoing is concerned. Dr. Anban Pillay, that's the person who at some point was the acting DG, and this is possibly the person who may have approved some of these contracts. Talk to us about how clean they are, if I could just put the question that way.
Right. In our investigation, as I indicated, that we have found quite a number of irregularities. And in our presentation yesterday, in one of the slides, right, we have said specifically to SCOPA that we are ensuring that at all levels there's accountability, right? Both those individuals would have been the accounting officers, and they've got the current accounting officer currently, right? So those ones would have been identified in the process and ensuring that they executed their function as expected by the Public Finance Management Act.
Yes.
Right? There is a section in the Public Finance Management Act, and in particular, I think it's Section 38, that spells out the responsibilities of the accounting officer, which is the Director General, right? So we would have tested whatever they have done in this process, because there's a responsibilities to ensure, amongst others, the PFMA says in that section, the accounting officer has to ensure that there's processes in place to ensure that the department has got processes to ensure a competitive process of procurement, right? So if there has been irregularities, then we would like to understand from the accounting authority what measures have they ensured that they are in place to ensure that there's a fair procurement process. If you fail against that test, then obviously we will return irregularity against you. So where we are with those is that we have included our findings in the report, and at this stage I would really, because you know very well that that report, I know the public has been calling for that report, but the President is considering that report, and there are processes at the moment. I saw yesterday there was a statement being issued that there are those third parties that needed to be notified because the report has been requested by other parties. Yes. So there is a Promotion of Access to Information Act, and it's got its own requirements. Yes. So I would really would like us to allow, firstly, the President to consider that and ensure that whatever findings are considered and acted upon, and when it comes to releasing the report, the Promotion of Access to Information Act to be complied with.
Yesterday, you were quoted in the media decrying the length of time that disciplinary action is taken against particularly accounting officers in as far as corruption issues are concerned, because you're saying that this is why there almost is impunity with which corruption is carried out, because it takes too long for people to be disciplined, and if it means them being fired, then being put out so that further corruption is stopped. And I'm raising this with you, Advocate Mothibi, because if we put prosecutorial matters aside and we deal with disciplinary measures, the two officials I'm speaking about, the DG and his Deputy Director General, Anban Pillay, so Dr. Buthelezi and Dr. Pillay, have their names been referred to the President for possible disciplinary action?
Right. As I said, we've made specific findings relating to irregularities that happened in the department, And we've made those findings and recommendations, which are contained in the report. Right? And at this stage, I think once the President would have considered that, we would really be in a position to pronounce. But suffice to say, we have found irregularities in the department, and the accounting officers would have had certain responsibilities in terms of the Public Finance Management Act, and we have really found them to be wanting, and we've made those findings in the report. Let me also just say, yesterday, to use your word, we decried the length at which general disciplinary actions take place, not necessarily only against the accounting officers. We have observed that there's no speed in dealing with the disciplinary actions. And we are really pleased that SCOPA also listened to us on that, and would also hold those state institutions to account to ensure that there's consequence management. What we said, in fact, what I said yesterday, was that all of these parts of the system, criminal prosecution, disciplinary action, and civil litigation, and other regulatory referrals, if all of these parts function effectively, they move with speed so that actions are taken, probably we are likely to see the impact that it makes, and we are likely to make sure that that culture of impunity is defeated, so that there would be deterrence to would-be maladministrators and those who still have the, harbor the intention to commit wrongdoing. So we call on, those processes to be acted upon speedily, so that there could be effective consequence management.
Advocate Mothibi, while we talk about the responsibility of officials, particularly those in the administrative processes, these are the people that actually make the approvals so that monies are paid out. The safety of whistleblowers, these are the very same people who, perhaps in their their consciences does not agree with what is being done, and they come out and say, I'm going to report this. And this issue of the safety of whistleblowers has become topical because of the death of Ms. Babita Deokaran, who belonged to the Gauteng Health Department, a department which you have been investigating. In fact, she was your witness.
Yeah.
Did you receive any reports as the SIU that her life was threatened?
No, thank you. Thank you for that question, Toli. We also picked up on that point yesterday when we presented, because it's part of the observations that we made even before yesterday's presentation in the previous report. In fact, when we presented our report publicly on the 5th of February of this year, I think that observation was already made around the safety of witnesses and ensuring that where they feel uncomfortable in handling the matters themselves, by law, they are allowed to bring in their legal representation. But your point is really around safety now. So we did not have any report about Ms. Deokaran being or feeling unsafe. And we've been really investigating in the Department of Health in Gauteng for a long while now. We started off interacting with the Gauteng Department on a secondment basis, investigating medical legal irregularities there where the Department of Health was involved. We investigated quite a number of irregularities. She was really a witness that provided the necessary information from the department's perspective. Now when the PPE investigation started, she continued in the role that she held in the department to provide the information that we required.
Yes.
So she was really a witness that gave us the information. Now, from the point of view of ensuring that the witnesses are safe, we do interact. Our investigators, when they interact with the witnesses, right? Amongst others, they are awake to the fact that we need to protect, for example, their identity. I mean, this witness, we've worked with her for a while, right? And that part of ensuring that it is not known that she is really our witness, we really believe that we have really managed to ensure that, we secure, her identity in that space.
But would her identity, and I'm sorry to cut in, would her identity, though, not have been known, and in particular, her assisting the SIU, would that information not have leaked to fellow colleagues within the department? Because some of the reports have suggested that she was actually being threatened from within.
Yeah, Toli, I mean, the role that she plays, of course, she works in a department with other colleagues, and it probably gets known in terms of the processes that she's responsible for. And I've really picked up in the public there that, there's some of the payment processes that she was also involved in, because in many instances, as SIU, when we pick up that there's irregularities with contracts, pending our civil litigation, we do advise the departments not to pay, right? And this is where we pick up that there's irregularities, and there's a number of companies that have not been paid in Gauteng Department of Health, simply because we've picked up these irregularities, and we are at court to make sure that there's a civil litigation decision to cancel the contracts. So the point I really wanted to make is that over and above here, there's a whole number of other witnesses that we work with, and they all provide a similarly important evidence, right? So our approach is that we really become awake that at any point in time, and this we really try our investigators to let the witnesses know, that if they are at any rate, at any point, feel unsafe or threatened, they should report to SIU or to SAPS so that actions can be taken to protect them. We have various examples where we have done this, and there is so-called what we call witness protection program in government, and it is under the auspices of the National Prosecuting Authority.
Yes.
We've got instances where witnesses, for example, in the Life Esidimeni investigation, we had various witnesses who said, one of them just rocked up at our offices and said, I'm not going back home because I've been threatened to be killed if I come back home. And we contacted NPA, and we ensured that with immediate effect, that witness, receives proper attention. So what we are engaging on now is to really ensure that there is heightened awareness, right? So that witnesses should know that if they are under threat, let them report to us, so that these measures that are in existence are used to protect them.
And I'm glad you used the word heightened awareness. I'm going to borrow from that and say, how heightened are your alert levels as far as this whistleblower who alerted you to the irregularity of the appointment of Digital Vibes in the health department? Because this person came to you, I think it was the 23rd of February this year, that alerted you to the Digital Vibes contract. How safe are they?
Right. Clearly, of course, we did indeed receive a whistleblower related to the Digital Vibe contract, and hence we started with the investigation. So we have taken steps to ensure that they are aware of all what I've been talking about, but I think even more to ensure that their safety is in place. We are reaching out to ensure that we put measures in place. We can't articulate all those measures now, but we have ensured that they are safe. Let me also come back to this question around the whistleblower versus witness, and I think there's also another usage of the word key witness and so on. They are used interchangeably out there in the public, and these concepts are not the same. A whistleblower comes to us and effectively blows the whistle and say there is this problem or there's this irregularity in a certain department, and he provides us with the information, and then we kickstart the process to report. We ensure that once we kick off the investigation, there are certain individuals that come up that becomes witnesses.
Yes.
Right? So you would have had a whistleblower that results in an investigation, and the investigation picks up witnesses in the process. Right? So we ensure that all of those measures are applicable to all of those. Now, in the case of this Gauteng investigation, we already were investigating, because we came in many instances. For example, these medico-legal investigations.
Yes.
They started in the Eastern Cape, right, where we worked together with the Eastern Cape government, Department of Health to investigate. We came up with irregularities. We traced some of the lawyers to Gauteng, some of the wrongdoers to Gauteng, and we started working with the Gauteng department on a secondment agreement.
Yes.
And in the process of kick-starting that investigation, there were witnesses that included Ms. Deokran, right? So she wouldn't necessarily have been a whistleblower in this context. And when the PPE investigations commenced, you rightfully said we would have received whistleblowers. That led us to the investigation, and the investigation produces witnesses in the process.
Yeah.
And those that become threatened or unsafe in the process, they let us know, and we ensure that the safety measures are in place. So we would really like, as we have said in our public statement, the witnesses to really be aware that they could report at any point in time to SAPS or to SIU when there's any way threat to their lives. And that happens also to our investigators, by the way,
yes.
Where they also get threatened, their lives at risk, and we take measures to ensure that they are protected.
All right. Advocate Mothibi, I'm completely out of time, and so I'm going to force you into a yes or no question.
Right.
Royal Bata is a company that you would have come across in Gauteng in your investigations of PPE corruption there. This was a company owned by the late Mr. Thandisizwe Diko. Is there a connection? Did monies flow from Digital Vibes, for some strange reason, to a Royal Bata account? Were there any links between these two companies?
If you look at our papers, the answer would say yes, Royal Bata does appear in some of those companies where there's movement of funds.
Wow. How much?
I don't have the exact figure now, but yeah, it's there in our papers. We have made sure that as part of assessing where the funds have flowed to, Royal Bata also does appear there. I don't have the exact figure now. And as I indicated initially when I started, that we continue to get new allegations slowly related to some of these aspects. And when we submitted the report on Digital Vibes to the President, we did indicate that should further evidence be presented, should further evidence come, we will continue to look at that, and we are continuing to look at that, and certain findings will be made and will be reported accordingly.
That's the SIU head, Advocate Andy Mothibi. Thank you so much for your time.
Thank you, Cody. We appreciate this opportunity.
Thank you, sir. We hope to host you again in the near future, so don't be a stranger. Thank you very much.
Thank you.
And good luck on the work that you do. That's the head of the SIU, Advocate Andy Mothibi.